Greetings to one and all. You're listening to MMJC Fortnightly Podcast. Generally, in our podcast, we discuss about the compliances to be undertaken by the companies and the complications involved therein. But this time, in our MMJC Fortnightly Podcast, we shall be discussing about a new form to be filed by LLPs. Actually, in October 2023, MCA had notified amendments to LLP rules by inserting new rules called Rules 22A and 22B in the said LLP rules. As per these rules, the LLPs are required to maintain register of partners in Form 4A. And also, wherever the registered partner does not hold the beneficial interest in the partnership, the same has to be notified to the LLP by the registered partner and the beneficial owner of the interest in Form 4B and 4C, and then the same thing has to be notified by LLP to ROC in Form 4D. There was one more amendment which was made in November 2023. The SBO related significant beneficial ownership related provisions of the Companies Act were made applicable to the LLPs, and MCA had notified LLP SBO rules for the purpose of compliance by LLPs. So as per these rules, the significant beneficial owner of the LLP is required to give the declaration to LLP in about his ownership in Form Ben 1, and the LLP is required to file the said declaration with registrar in Form 4 Ben 2. Since, in spite of the fact that the amendments have been notified in October and November 23, the forms for giving effect to these amendments have been deployed just now. So, therefore, in this edition, we shall be discussing about these forms 4D and Ben 2 respectively. And to guide us in this regard, we have with us Mr. Nachiket from Secretarial Team of MMJC. Welcome, Nachiket.
Thank you, Rutuja. Thank you for having me on this podcast.
Okay. So before we move to the actual forms and provisions, first tell me one thing. The Section 5 of LLP Act says that only an individual or a body corporate can become a partner of a LLP. Whereas if we refer to LLP SBO rules, it talks about firms, Hindu undivided families, and trusts becoming partners of HUF. LLP. How does this make sense?
Well, this makes sense due to provisions of Section 42 of the LLP Act 2008. Section 42 says that economic rights of the partner to receive share in the profit or loss can be transferred, and this does not amount to dissolution of partnership. By the virtue of this provision, a trust, HUF, or a firm can become partner through its trustee, karta, or a partner, respectively. These individuals shall become partners of LLP, and the economic/beneficial interest shall be transferred by them to trust or HUF or a firm, as the case may be.
Okay. And what if the trust is a SEBI registered REIT or an InvIT? Can it still become a partner of LLP?
So, through a circular issued in 2014, MCA has clarified that any SEBI registered trust whose trustee is a body corporate can become a partner in LLP through such trustee. Therefore, a SEBI registered REIT or InvIT can surely become partner in an LLP.
Okay. Now, before moving ahead, first tell me what is the purpose of these forms? I mean, as per LLP rules, which form has to be filed for what purpose?
Okay, so as discussed earlier, as per Section 42 of the LLP Act, it is possible for the partners of LLP to transfer their economic interest in the LLP to someone else. Therefore, it is possible that one person is a partner but does not hold economic interest. So now, as per Rule 22B of LLP rules, if any partner is a registered partner, that is, his name is entered or registered in LLP agreement as a partner, but the beneficial interest is held by someone else, then the registered partner has to disclose this fact to LLP along with the details of the beneficial owner in the Form 4B. And the beneficial owner also needs to declare this fact to LLP in the Form 4C within 30 days of the name of the registered partner being entered in the register of partners, and thereafter for any change in that regard. Thereafter, the LLP will have to file these disclosures received in the Form 4B and 4C to ROC in the Form 4D. Since the eForm 4D is deployed now, So if any declarations have been received from the notification date till now, then those need to be filed in the form 4D now. The timeline for filing this form 4D without additional fees is still 1st July 23.
Okay. So basically, whatever description you gave, it appears that Form 4D closely corresponds to Form MGT6 that is filed in case of beneficial ownership in the companies. Is it right?
Absolutely.
Okay. And what about Form LLP Bend 2?
So as per MCA notification dated 2nd Feb 22, Section 90 of the Companies Act is applicable to LLP as well. Thereafter, via a notification dated 9th November 23, LLP SBO Rules 23 were notified, wherein the formats of Ben 1, Ben 2, etc. were curated for LLPs. And the timeline of 3 months were given for the SBOs of LLPs to file the form LLP Ben 1 with the LLPs. But eForm LLP Ben 2 was not yet deployed on the MCA website, which has now been deployed now. Therefore, if any LLP has received LLP Ben 1 LLP form from any SBO, then that LLP is required to file that declaration in the form LLP Ben 2 now.
Okay. So basically, you mean that if any person, be it a natural person or an entity, is registered partner and the beneficial interest is held by someone else, then the LLP is required to intimate ROC about such beneficial interest in Form 4D after the declaration is received from registered partner and beneficial owner. And secondly, if there is any significant beneficial owner in the LLP, then declaration in that regard has to be received by LLP from the owner, and then same has to be filed in Form BENT, correct?
Right.
Okay. But are these forms mutually exclusive or dependent upon each other? I mean, if one form is filed, is the LLP required to file another also, or what exactly is the scenario?
That's a very good question. So there can be a different permutation combination for each LLP. Suppose there is one LLP wherein there are 3 partners, okay? One body corporate holding 95% contribution and 2 individuals holding 4% and 1% each. The individuals are now registered partners as well as beneficial owners. In this case, since both individuals are partners in their individual capacity, so only SBO analysis needs to be done by the body corporate only, which is holding 95% contribution. If there is any SBO, then LLP Ben 1 will have to be given by SBO to LLP, and then LLP will have to file the form LLP Ben 2. So there is no need for the LLP to file the form 4D here. Let's take another scenario. There is one LLP wherein there are 2 partners, one body corporate holding 99% and one individual holding 1% contribution. That individual in this case is a nominee of the other body corporate partner holding 99% contribution. And this arrangement is just because of the reason that LLP needs at least 2 partners. Okay. So in this case, for the 99% contribution held by a body corporate partner, the SBO analysis needs to be done and LLP Ben 1 must be given and the eForm LLP Ben 2 must be filed. But for the remaining 1% contribution, the declarations in the form 4B and 4C need to be received from that nominee, that is the registered partner and the beneficial owner. And then the LLP should file the form 4D to the ROC. So in this case, both the eForm 4D and eForm LLP Ben 2 needs to be filed by that LLP.
Okay, so that means which form will be applicable, whether one of them will be applicable or both have to be filed, that depends upon the ownership structure of each and every LLP separately.
Absolutely.
Okay, so my next question pertains to the exemptions from this form. In case of Companies Act, where the holding company has a significant beneficial owner and holding company has filed Form Ben 2, then in that case, when subsidiary is filing Form Ben 2, it is simply required to enter the SIN of the holding company who has filed the form, and it can file the form. It is not required to attach Ben 1. So is this same exemption applicable to LLP as well? I mean, let me clarify with the example. So if A Limited is a holding company of B Limited and B Limited is a holding company of C Limited, and the A Limited, which is the ultimate holding company, has a significant beneficial owner, Mr. X. So Mr. X has given Ben 1 declaration to B Limited, and B Limited has filed Form Ben 2. Now, when the subsidiary of B Limited, that is C Limited, goes for filing this form, it will simply enter the SIN of B Limited and will file the form. So, is this same if in case the C Limited is a partner in a LLP and it holds significant majority stake therein, then will Mr. X, the beneficial owner, have to give declaration separately separately to LLP, or the one given to the B Limited would suffice?
Okay, that's also a very good question. So if we refer to the Rule 8 of SBO rules under Companies Act that talks about non-applicability of SBO related provisions, it provides a clear exemption to holding reporting companies. And that is why in this example given by you, Mr. X is not required to give Ben 1 to subsidiaries of B Limited. However, if we refer to the Rule 10 of LLP SBO rules, which also talks about non-applicability, it does not provide any such exemption pertaining to holding reporting LLP. Probably because unlike Companies Act, there is no concept of holding LLP in the LLP Act. Therefore, in the example given by you, if B Limited holds more than 50% contribution in any LLP, then Mr. X will have to give declaration to such LLP in the form Ben 1. However, there is one point worth noting here in this behalf, that even though LLP SBO rules do not provide any exemption to holding LLP, yet the form Ben 2 provides in its purpose an option for declaration of holding reporting LLP. Now, the point here is that when there is no concept of holding LLP under the Companies Act, under LLPs Act, then on what basis will the reporting LLP declare any other LLP as its holding LLP? Also, when the rule does not provide any exemption, then can form provide the same? So clarification in this regard is to be appreciated by MCA.
Okay, so till the time MCA clarifies on this aspect, the LLPs are expected to go ahead with the filing.
Right.
So, can you highlight some things about the actual filing of the form, like their due date, the filing fees, attachments, etc.?
Sure. So as mentioned above, the eForm 4D as well as eForm LLP Ben 2 generally has to be filed within 30 days from receiving declaration in the form 4B and 4C or Form Ben 1 as the case may be. But the first time filing of these forms to intimate the status as on the date of notification has to be done on or before 1st July 24. Thereafter, it will be considered that these forms are filed in a delay and with additional filing fees. These both forms are STP forms and cannot be resubmitted. Therefore, caution has to be taken about the accuracy of the information. With respect to your question related to the filing of fees, the fees for the form 4D is rupees 50 for small LLPs and 150 for other than small LLPs. And also with respect to the fees of LLP Ben 2, the filing fees is depending upon the total contribution of the LLP in the respective case.
Okay. That was a very elaborate information, Nachiket. Thank you very much. And most importantly, since it was accompanied with examples, I'm sure our listeners would have understood it very clearly. So, thank you for listening to us. Please feel free to write to us about your feedback at mmjcinfo@mmjc.in.
Thank you, Rituja. Thank you all.